Welcome to Seoul News Live. I am Rich Tiham and this is your daily source of corporate news. One of the most popular companies in the Philippines, Ayala Corporation, has a major case with the Securities and Exchange Commission. As of this morning, there was a pending consideration of the amended Articles of Incorporation and bylaws of Ayala Corporation by the Commission and Bank of the Securities and Exchange Commission. Said amendments consist of the reduction of the number of the Board of Directors from 11 to 5 and that of the membership in the Executive Committee from 5 to 3, respectively. Now, the question is this a valid and legitimate exercise of Ayala Company's corporate powers? We'll get to know more of this story from Cyril Copino.
That is right, Rich. The Securities and Exchange Commission has issued a resolution denying the instant petition of the Ayala Corporation for the approval of its amendments to its Articles of Incorporation. In the resolution signed by Chairman Rosario and Lopez and Associate Commissioner Armando Gonzalez, the corporate regulator refused to accept the amendments laid down by the Ayala Corporation to its Articles of Incorporation. The proposed amendments include the reduction of the number of the Board of Directors from 11 to 5 and that of the membership in the Executive Committee from 5 down to 3. Ayala Corporation claims that amending its articles and bylaws is a legitimate and valid exercise of its corporate powers.
Right. But that has always been the case. Every time there's change, the people who feel like they have been aggrieved will try to find fault and try to revert things back to the way that and push to revert things back to the way that they have been used to, But Ayala Corporation's amendment of its articles and bylaws was done in a legitimate manner and is a valid exercise of the company's corporate powers as vested in the stockholders. In fact, this matter was approved by our stockholders representing 87.3% of the corporation's total outstanding shares. And in that meeting, all the significant majority groups, except for one who was duly notified of the meeting but who couldn't make it, however, sent a representative without proxy, none of the stockholders objected to or voted against the amendment. So we stand in the position that there was no irregularity in this matter, that this is legitimate, and that the company was merely exercising its corporate powers.
Meanwhile, President and General Manager of Armstrong Securities, Tony King, expressed his objection to the amendment, saying it will prejudice the minority shareholders' rights.
Let us take a look at this. Let us say the corporate affairs could be better served with a lesser number of directors. But how about the minority stockholders? These amendments will certainly result in the diminution of the rights of the minority stockholders. That is why I strongly object to these amendments, because these will not only prejudice, but these will also disenfranchise the rights of the minority stockholders to participate in the management of the company. And once this is approved, its approval would set a discouraging precedent that would also affect the future of the stock trading in the country.
Stella Bray of Lanao Commodities also voiced out her disapproval of the modifications.
You know what? These amendments indicate a clear move of the Ayala Corporation management to reduce the participation of the small and minority stockholders like us. That is why I'm writing to the SEC to request for the disapproval of these proposed amendments.
In its resolution, the SEC stressed that the amendments applied for by Ayala will result in far-reaching implications and is set to affect the rights not only of present but also of future stockholders of the corporation. The Commission also reiterated its authority of protecting the investing public in order to create a better investment climate that would enhance greater economic opportunities, as mandated by Presidential Decree Number 902-A as amended and under Section 143 of the Corporate Code. The Ayala Corporation is the country's oldest and largest conglomerate. It is listed in the Philippine Stock Exchange and its shares are publicly traded. Live here in Mandaluyong City, Cyril Copino for Seoul News. Back to you, Rich.
Thank you very much, Cyril Copino. Joining us today are corporation law experts, Attorney Dara Lopez,
Good afternoon, Rich. Thank you for having me here.
And we also have one of the most popular corporate lawyers, Attorney Ayel Manlogon.
Thank you so much for having me. It's great to be in the show. Thank you so much for guesting us.
So attorneys, thank you very much for being with us today. With the issues at hand due to the amendments of the Articles of Incorporation and the bylaws of the Ayala Corporation, my question is, can these proposed amendments to the Articles of Incorporation and bylaws be given due course?
So, to answer that question, I will cite the infamous Mr. Justice Wayne. He said that the alteration must be reasonable, they must be in good faith and consistent with the scope and object of the incorporation. Sheer oppression and wrong cannot be inflicted upon the guise of amendment or alteration. So, is the amendment in good faith here? No, the proposed amendment will definitely affect the rights of the present and future stockholders, and hence cannot be given due course.
Also, here, there can be no doubt that the reduction of the number of board of directors from 11 to 5 members would result in the freezing out of the minority. It has been generally recognized that there are equitable limitations on the exercise of the amendment of power even when an amendment is adopted by the requisite statutory numbers of shares together with any required class vote.
Thank you for answering that. Many of us are also thinking of the authority of the Securities and Exchange Commission. So can the Securities and Exchange Commission look into the validity of these amendments?
Yes, as provided by the Corporation Code, the Securities and Exchange Commission, or SEC, shall have the power and authority to implement the provisions found in the Corporation Code. They are also authorized to promulgate rules and regulations necessary for it to perform its duties.
So bear in mind that even though it is a reserved right for the corporation to repeal its own contract or articles of incorporation, the SEC exercises the power of regulation and control in the interest of the public.
Attorney Dara and Attorney Ayel, thank you very much for answering our legal queries.
Thank you so much for
Thank
having
you.
us.
This is just in. The Securities and Exchange Commission has issued its resolution just now. We have with us live the Chairman and SEC Commissioner Rosario Lopez to discuss the ruling to the Ayala Corporation's case. Commissioner Lopez?
Hi, Rich. Good afternoon. Good afternoon to our viewers. The amendments to the Articles of Incorporation consisting of the reduction of the number of board of directors from 11 to 5 and that of the majority in the executive committee from 5 to 3 respectively is denied. The reason for this, Rich, is based on the Corporation Code, which provides that the amendment must be for legitimate purpose. And certainly, the purpose of freezing out the minority cannot be legitimate. In this case, even when an amendment has been regularly approved by the board of directors and by a majority shareholder or holders, the relatively unlimited contractual right to amend the articles becomes subject to overriding equitable considerations if the majority has used its position without due regard to the interests of the majority stakeholders. We must remember, Rich, that the fundamental principle in corporate law is that the reserved power of a corporation to amend its charter must be so exercised that the result will tend to benefit the corporation as a whole, and to distribute equitably the benefit or the sacrifice, as the case may be, between all groups in the corporation as their interest may appear. It is immaterial that amendments have been approved by majority of the members of the board and more than 2/3 of the outstanding capital stock. Jurisprudence provides that it is no longer seriously debated that majority shareholders owe a duty to at least act fairly to the minority interests, and the majority cannot avoid that duty merely because the action taken is legally authorized. But on the other hand, this does not mean that the directors or the majority shareholders should not be permitted to exercise their powers arbitrarily or without due regard to the legitimate expectations of the minority shareholders, and many of the older decisions, and practically all of recent ones, indicate that controlling shareholders in some circumstances at least owe fiduciary duties to minority shareholders, and that the courts will require them to observe accepted standards of business ethics in transactions affecting rights of minority shareholders.
So given these statements, our question is, can the Commission look into the validity of these amendments?
The answer is yes. Under Section 143 of the Corporation Code, the Securities and Exchange Commission shall have the power and authority to implement the provisions of this code and to promulgate rules and regulations reasonably necessary to enable it to perform its duties hereunder, particularly in the prevention of fraud and abuses on the part of the controlling stockholders, members, directors, trustees, or officers. So, while the reserved right is in the interest of the state to modify or repeal its own contract with the corporation, it is in reality a continuing power of regulation and control in the interest of the public. The Commission must disapprove the subject amendments inasmuch as the same constitutes oppressive conduct towards the minority stockholders who by said amendments are deprived if a sporting chance to be represented in the board. Again, Rich, we'll go back to the statement of President Ramon Magsaysay. It is only fair and just that he who has less in life should have more in law. So that's all on my end, Rich. Thank you very much.
Thank you very much, Chairman. We are really honored to have you in our show. Now, we will know the opinions of the people. Do they dissent or would they concur with the decision of the Securities and Exchange Commission? Let us find out as Cyril Copino reports.
Thank you, Rich. Now let's get the pulse of our citizens regarding the resolution by the SEC. Are they in favor or against it? We have on the line Ms. Marlene from Taguig City. Good afternoon, Ms. Marlene. Let me ask you, do you agree with the recent ruling of the SEC and the amendments of the Ayala Corporation to its Articles of Incorporation?
Thank you for giving me this opportunity to voice out my dissenting opinion on the decision of the SEC. So let me enumerate my points then. Number 1, the function of the SEC in processing the Articles of Incorporation is merely ministerial and not discretionary. Hence, if based on the incorporation papers, every requirement for amendment has been complied with, then all it has to do is to process the amendment. Number 2, under the Due Process Clause of the Constitution, we have what we call economic liberty, which entitles an individual or entity to do anything it pleases in the economic field, subject to the exercise by the government of its inherent constitutional and statutory powers. Number 3, while each stockholder has a right to vote under our existing laws, there is no certainty that the consequence will be able to elect a director to represent their interests, even with the use of cumulative voting. Number 4, matters like increasing or decreasing the number of directors or amending the Articles of Incorporation or bylaws requires the exercise of business judgment. So, in the absence of clear constitutional or statutory provision granting the power to do, then government functionaries like the SEC should not frustrate that business judgment of the corporation. Number 5, none of the grounds for rejection of Articles of Incorporation as indicated in Section 17 of the Corporation Code exists in this case. Number 6, the issue of morality under Section 17 of the Corporation Code only refers to the purposes for which the corporation is organized, and it cannot be applied as a standard for each and every purpose of each and every act of the corporation of its component members or stockholders. Number 7, the requirement under Section 16 of the Code is that the amendment or provision in the Article of Incorporation must be for legitimate purposes, meaning it must be legal. Hence, standards of morality according to religious precepts does not apply here. Number 8, there is no showing that the procedure for removal of directors as prescribed in the code was not followed by the corporation. Hence, there is no violation of the law. Number 9, the law grants the right to amend the Articles of Incorporation to the stockholders representing at least 2/3 of the outstanding capital stock. That is the present state of the law, and that is what happened in this case. Hence, considering all what I have said, there is no reason why the SEC should disapprove the proposed amendments. So that's all, and thank you very much for this opportunity.
Thank you, Ms. Marlene. We also have here Sir Mark from Makati City. Do you agree or disagree with the SEC resolution?
Yes, I am actually aware of the issue. And with that, I can say that I concur with the decision of the SEC in denying the application of Ayala Corporation for the approval of its amendments to its Articles of Incorporation for the following reasons. One, as far as I know, the Corporation Code authorizes the removal of a director with or without cause by a vote of the stockholders holding or representing two-thirds of the outstanding capital stock. However, this must not be used to deprive the majority stockholders or members of the right of representation to which they may be entitled. And the stockholders are entitled to cumulative voting, and as such, the minority stockholders are afforded the opportunity to be represented in the board of directors. So, with that, I can say that the approval and the denial of the proposed amendments ultimately depends on the question of whether or not said proposed amendments would deprive the minority stockholders of their opportunity to be represented in the board of directors. So I think we should be concerned not only with the fate of a particular minority director, but more importantly, in the opportunity for minority representation, not only now, but in the future. So, with that said, I would concur with the SEC decision. Thank you.
There you have it. We've heard about the stand of our citizens regarding this issue. Again, this has been Cyril Pupino reporting for Sol News.
Thank you very much, Cyril. We had a poll, and majority of the members of the group voted for the concurring opinion. Thank you very much for watching. We hope we were able to help you get a grasp of the case of the Ayala Corporation. I am Rich Tiham, and this is Seoul News Live.